Hi everyone, my name is Joseph, and we're doing this live session today. And bringing bad news, we're seeing the denials starting to come in with a lot of the 75 country bans, pauses. Our clients from Nigeria went to the consulate. Everything was good, but got the denial notice, and it wasn't the denial notice that we expected either. So today's live session, we're gonna talk about the 75 country ban. I know since the last video went out last week, we got a lot of questions. And if you guys have other questions now, feel free to ask as well. So just like all the live sessions we do, we're going to do a news story. But today we're going to do two news stories. One is surrounding the 75 country ban. The second one is regarding what's happening on the ground with the customs officer at the airports, specifically LAX, JFK, New York, Los Angeles, and San Isidro. We have a lot of clients that go through these entry points. We see it, around the US. And I can affirmatively say the policy surrounding people who are entering the country, it is getting strict. It is getting back to pre-COVID. There hasn't been any official memos on it, so we're just immediately reporting what we're seeing. And we're going to go into depth about that. So there's these two big news stories that we're going to be talking about. We're going to be releasing them separately in separate videos so you can see it. And then we're going to do a success story regarding EB1A extraordinary ability client who got it approved in 2022, came into the US as a B1, B2 tourist visa, and then adjusted status because the priority date is current. And then he got called into two interviews. What happened? How does it go down? Why are they being so strict with B1, B2 tourist interviews, even for people who are EB1A approved? So we're going to go into those details. Right, so 3 separate segments, and in between each one, we'll answer questions as we normally do. So feel free to let us know whether you're on TikTok, YouTube, or Instagram. We're here trying to do as much as we can to help everyone. And again, if I say anything wrong, I'm sorry, right? We always try to correct ourselves. But today, I want to start with the 75 country ban, 75 country pause. To recap for people who don't know, the White House administration declared it, immigrant visa processing updates for nationals at high risk or of public charge usage. So one of the countries was Nigeria, and we had a client go in for a normal family petition immigrant visa interview, and they were denied under 212F. And it is saying it's pursuant to the Presidential Proclamation 10998, restricting and limiting the entry of foreign nationals to protect the security of the United States. And so you are ineligible. I don't know how long we had to go through, talk through this with the client, right? Because it's not inadmissible. It is not a denial. It is not a return to USCIS to re-adjudicate. It is not an admin processing. It is ineligible pursuant to a White House proclamation. What does that mean? And it is not the public charge 75 rule pause to immigrant visa, which was what we were expecting, which was what we're preparing for. But what does this mean? So for people who are unfamiliar with the consular process, when your immigrant petition, whether it's for business or family, gets approved in the US, you go through the National Visa Center and then you go to a consulate for the interview. Then they give you the visa, then you come to the US. Well, what happens if your visa interview doesn't get approved, right? What are the scenarios? The worst scenario is that they say you are inadmissible. We have discovered something in your background where maybe you committed fraud before, maybe you are a health risk, maybe you are a criminal. And so therefore, even though USCIS approved it, even though you waited all this time, even though you paid all this money, you are inadmissible. You may or may not qualify for a waiver, so now you can apply for a waiver, right? So some people who have been unlawfully present in the US for a long time, they go back to their home country, they apply for this, and they are inadmissible. The worst of these are like the DACA recipients. They leave the country, they think it's all fine, they were misinformed, and then the consulate says, sorry, you are still inadmissible, you have unlawful presence, and so now you need to apply for a waiver, and now they're stuck outside of the country. So that's inadmissibility. Second, which we also commonly see, is they do like a lengthy admin processing. It could be 3 months, it could be 6 months. Sometimes it's like 2-3 weeks. But again, we have seen something for like 6 months to a year where they have to thoroughly investigate you back in your home country. While you're stuck, you cannot leave, right? So, and it's, a lot of times they actually take the passport. Then the third option is they say, you know what? we're going to return this back to USCIS to re-adjudicate your case. We see this for K-1 visas. We see this for a lot of business visas, E2, I-129, a lot of different things we filed in the US. It's like during the interview, we discovered something that maybe the USCIS officer didn't adjudicate correctly. So please go back and re-adjudicate. That's also a nightmare for a lot of people. But then now, on top of these three things, right? Approval or inadmissible or admin processing, and returning it back to USCIS. And now we're saying, well, you are ineligible pursuant to the proclamation. Really, that just means they want to approve the visa, but because of this policy, they cannot just yet. You have to wait for the pause to be lifted unless you apply for a national interest exception, then they might approve it. So that's the current situation for everyone who's part of the 75 countries who is trying to get a visa abroad. So this is the big news that I want to share. Since COVID, the world of customs have completely changed, more than 180, right? Pre-COVID, pre-2020, you can go on Google history and you could check out how many people bashed and hated on and ridiculed and laughed at the customs officers. And to the point where there were heavy lawsuits between the private bar. You know how people feel about ICE right now? To a lesser degree, because at least CBP officers weren't, killing people. That's how people felt about customs officers pre-2020. People who, Canadians, Mexicans, different people who left the US for mere months, 3 months, 4 months, 5 months. They come back in, green card gets confiscated, gets harassed, gets put in secondary for 8 hours, 9 hours. It's unthinkable. Since COVID, for the past 5-6 years, customs have been a lifesaver in the immigration world. They've been the heroes. They've been the stars because the consulates were shut down, the USCIS was shut down, and a lot of times they were the only ones who have the remaining discretionary authority to help people. With that increased flexibility, with that increased power at the airports as well as the land border, that unfortunately caused a huge surge in illegal immigrants. But to at least speak on behalf of the CBP officers, it's not them that's the problem. It's the infrastructure. They're still there reviewing, record amount of people, 40,000 people, entry every single, month. So, but that became a problem. And for the past 5 years, since 2021, I've been going to a lot of these national conferences with CBP officers, with local conferences with CBP officers, and I go down almost on a monthly basis to see CBP officers and talk to them. What are the policies? And they've been saying for the past 5 years that it is getting stricter, it is getting stricter, it is getting stricter. We have seen it gradually getting stricter from 2021. This month, January 2026, I can affirmatively say that almost on a nationwide platform, we are seeing that they are getting strict to the point where it's almost pre-COVID. So it's returning to the original policy, meaning if you left the US for 3 months, 4 months, 5 months as a green card holder, there will be some challenges. There will be secondaries. We have, just this month, German clients who got their EB5 case first month getting the green card, sliding back and forth, already challenged. That's insane. That's unheard of in the past 5 years, even pre-COVID, right? So, strong US allies, whether you're European or Canadian, green card holders merely leaving for a short period, being harassed by customs at international airports, JFK, LAX, and other places. And these are already the best airports, in my opinion, right? So if you go to a smaller airport that doesn't see a lot of these international travels, they might be even stricter, right? You leave the US for over 1 year, 2 years, 3 years, we see NTAs, notice of intent to appear, directly being issued. Forget deferred inspection. They don't even want to listen anymore. They see your case, beyond my pay grade, we're going to send you to ICE. Why is this happening? There's a lot of explanations. Maybe one of the big explanations is that finally, ICE is beginning to have the capacity to process it. In the past 5 years, there were so many other things going on. If we want to remind ourselves, Ukraine, Israel, Palestine, Afghanistan, right? All that, and COVID, of course, right? it was flooded with problems. With the funding that ICE got, with the expansion of detention centers, with the pressure of the quota that they failed to meet, is it reasonable to think that ICE is putting pressure on both USCIS and CBP to say, hey, give us people? And CBP, based on the law, if you left the country for over 6 months, if you left the country for over a year without a reentry permit, well, you might have abandoned your residency, so we have to give you an NTA. Now, you have to go for a check-in. USCIS, when they deny an adjustment of status, well, it's been the law since, the memo came out in 2019. We're supposed to issue NTAs after every single denial. So now, a lot more cases, when it's not successful, you suddenly have an immigration court hearing and ICE is in charge. And you have to do monthly check-ins, especially if there's an absent order against you. We're seeing all of this, and we saw a lot of it this month, all happening at once. Now, a small part of me is hoping that that is not the case. A small part of me, ever since November, December, because it's Thanksgiving and it's Christmas, a lot of tourists are coming in. A lot of CBP officers are only issuing 3 weeks to a month entries for a lot of B1, B2 tourist visas. They're tightening their review because, there's big world events happening soon in the US, whether it's big conferences, whether it's FIFA, if it's still here, or it is the Olympics. They're tightening their review. But for green card holders, just today, Europeans who flew in got severe warning, but they have to travel out immediately. They need to file emergency reentry permits. Found us, we're processing it, we're filing it, right? Again, in the past 5-6 years, I rarely saw that kind of scrutiny against Europeans, especially Western Europeans and Canadians. Other countries, sure, right? And whether you think that's fair or not, that's the officer's discretion. But now we're seeing direct NTAs. And when you get a notice of intent to appear, let me just walk you through the headache of it. A lot of people who are green card holders, they have businesses, they have homes outside of the US, they have a whole family, they need to come here for something and they need to leave. And if it's a short trip, they never thought about having to apply for a reentry permit. In the past, they would get a warning. Now, without a warning, you get an NTA, and what do? You're stuck. Your court hearing could be 6 months from now. You have to get a 551 stamp. You leave, you come back, you'll be detained, or you'll at least be heavily reviewed for potentially 8 to 9 hours with CBP and ICE before you can be released. It becomes such a difficult ordeal. And that is what I want to share, because I don't see this online. I don't see the news talking about it. And if this is a trend, it's going to get worse and worse. And it is a drastic change from just a few months ago. People who have green cards trying to come back into the United States, if they've left for more than 6 months, is beginning to really face a big scare. And tomorrow, right, I'm trying to help 2 clients come back into the country, and they've been out for like over 5 years. And so it's going to be a big battle. I hope we win it. I'll definitely talk about it once we do. But just want to share the news that green card holders coming back in, CBP adjudicating people is getting stricter, regardless of your ethnicity, regardless of your country of origin, regardless of your status, whether you're EB1A, EB5, or family-based. What is the cause behind it? Maybe it's ICE, maybe it's not ICE. There's so much conspiracy theory, but just definitely prepare well.
Do you think for a marriage visa, the evidence I have is taxes filed jointly, we have phone bill together, life insurance, and car insurance. Do you think that's good enough?
To prove your marriage is real? No. And the reason I say that is because the officers think most of these cases are fraudulent. So if other people who have fraudulent cases are doing way better than you, that becomes a problem. Now, I'm not saying like you'll have a hard time for sure, but you could do way better than that, right? And so, especially if you have many red flags. So statistically, how likely are the two of you to be together? Look at your race, socioeconomic status, education, friend group, your circumstance, right? I think we all watch the same type of movies. We all know rom-com. If it's too dissimilar, that piques the officer's curiosity, right? So you definitely want to provide a lot more than what can easily be done by fraudsters.
Does attempted theft conviction bar me from adjusting my status? I have 1 year probation.
My recommendation is you take your conviction record from the court, right? The final minutes conviction record, what is your sentence? What do you have to serve? What is the conviction? What is the statute in that county, in that state? Block out your name, upload it, double checking. The question you want to ask is this inadmissible? Is this deportable? And the reason why I'm not telling you right now is because there's too much information I don't know, right? What is the statute? What is the sentencing? What is the potential sentencing? Is this a good moral character flaw? What is an officer likely to challenge? How can you overcome it? If all the AI says most likely not, you might have a good chance. You just want to prepare a good moral character analysis to boost your case. You're going to have to disclose it. You're going to have to answer it. You're going to have to prepare a good packet to show that you have suffered remorse and that you have been reformed. Those are all really important. But if all the AI directly says, yes, this is inadmissible, yes, it's deportable, well, you have your answer, right?
Does military parole in place work for people who have removal orders?
We've tried and it worked. We've tried and it failed, and then it worked in a different way, right? In the sense of we tried to do parole in place, and USCIS admitted that there was an admission, there was a parole, but we cannot adjust your status. And then we took that to the removal court, immigration court, at the individual hearing and say, look, USCIS said that there was admission, and so therefore we can adjust now. So I think that's the best way to answer you. It could work at the USCIS stage. If not, it could work at the individual hearing stage. You really want to go in depth to talk about your case.
Do you know the time frame for a U.S. citizen sibling to petition a married DACA sibling from Mexico?
Petitioning sibling from Mexico, if my recollection, could take decades.
Can you handle E2 visa?
We do a lot of E2 visas. So I don't know how you found us, but if you go on our YouTube channel, you can see all the different E2 cases that we do. There's a different playlist for each different category, E2, L1, EP1A, all the fun stuff. We do a lot of E2s. And today's news segment, so stay for that, is we're going to be talking about what's happening at the border and also at the airports, because that affects E2 people significantly.
What does it mean after immigration interview for marriage, the case is being actively reviewed by USCIS? I
wouldn't read into that. It just means it's not closed yet. I wouldn't read into what the online system is saying.
Do I need to worry if my husband has a green card? He is here legally.
The current state of immigration in the United States is that if you are a citizen, if you are born a citizen, but you don't look like what the media portrays a U.S. citizen should look like, you might be treated as if you are maybe a sworn citizen, a naturalized citizen. If you're a naturalized citizen, you might be treated like you're a lawful permanent resident. If you're a lawful permanent resident, you are now being treated as if you just have a visa, a work permit. If you have a work permit, you might be treated as if you don't have lawful status. If you don't have lawful status in the United States without paper, you are being treated like you are a terrorist, a criminal. And if you're a criminal, you are treated as if you are an enemy of the state. That is what is happening. I don't think anybody would dispute that. I think we all see it on the news. I'm not trying to scare anyone. I don't think you need to be worried, because I believe in the judicial system in the United States, and I think it is still good, especially if you have a lawful permanent resident. But as I will tell you later on with the different news channels, news stories, a lot of LPRs, a lot of green card holders are getting their rights taken away from them. And it is a very scary time. My advice is, whatever status you are in this hierarchy, I recommend, if it's possible, move up a ladder. In the past 30, 40 years, this folks was here since 1980. Most people who are green card holders do not choose to become citizens because they like the privilege of a green card. They don't need a citizenship. Having a citizen is not that significantly better. But in this day and age, we do recommend getting it if you want that extra protection.
Can a citizen travel to one of the banned countries?
I do not recommend it, right? Now, you're traveling to a banned country. Just to be specific, the ban is banning the consulates from issuing new immigrant visas. It is not banning non-immigrant visas. It is not banning national interest exceptions. It is not banning U.S. citizen services. Let's say you fly over there, you need to do a notary, you need to do a birth certificate, you need to do an N600, right? All still happening. So, U.S. citizen flying in and out, fine. But just wouldn't recommend it because customs, everybody is very on high alert.
Are they sending immigration court dates this year for next year?
No. Well, I mean, I think it was just yesterday morning we had 2 immigration hearings. Things were scheduled within a month. A lot of things are scheduled within a month.
Is it easier for my husband to get a green card with his DACA or advance parole, or me petitioning for him?
Your husband has DACA, has advance parole. So after coming back with the advance parole, based on the marriage, he will file adjustment of status through the marriage with you. So it's all of the above, right? You petitioning him, I-130, because he had an advance parole and he entered the U.S. Then he files a 485. He goes to the interview and he gets a green card, right?
Can you apply for citizenship if you're from one of the banned countries?
From the 19 country? No, right? It's a pause on all benefits. So we did a consultation just a few weeks ago. They were at the last stage of the interview. Interview was passed with flying colors, but no oath ceremony being issued. So just waiting, right? Just continuously being a lawful permanent resident. But if you're part of the 75 countries, well, you already have a green card and you can apply for citizenship. That is still ongoing. And anything that's happening, if you're part of the 75 countries and you're in the United States, it is not a pause, right? The White House proclamation only affects the State Department, does not affect USCIS.
And can you apply, like even start the process, get the priority date, or...
Yeah. So if you haven't even started the process yet, you can, because the pause is only on the last step, right? So you can start the I-130, you can wait for the priority date, you could go through the National Visa Center. All of that takes months, if not years, depending on which category you are. So you can do all of that. It's just that at the last step, after the interview, normally admin processing 2 weeks, 3 weeks, then you get the visa. Well, instead of that 2-3 weeks, now it's indefinite. My prediction is it might be 3 years. So,
can you travel to another country if you're an LPR?
Yes, you absolutely can and have the right to when you come back, depending on where you went, how long you left. That's how CBP officers going to scrutinize your entry.
Do you know how long citizenship applications are taking?
We always estimate 9 months.
My green card expires this October. Should I pay for the renewal and apply for citizenship?
For most people, if you're not going to travel, you have a clean case, I would just apply for the citizenship. No need to spend double the money. Especially, the I-90 renewal might take even longer than your N-400, ironically. However, if you have a weak case, your N-400 might be denied because of your frequent travels, because of your criminal record, because of some mishap. And you might want to withdraw the N-400 right before it gets denied. If that is part of your strategy and that's part of your risk, then totally file the I-90 and the N-400. So if the N-400 doesn't go through, you still have I-90.
If you have a green card, you live in the U.S., and you're from one of the banned countries, I assume the 75 banned countries, consular pause, can you apply for citizenship?
Yes, because you're in the United States, you're filing citizenship with USCIS, and you can get it.
Why are DHS trial attorneys winning most of the cases in immigration court against private bar attorneys?
I wouldn't necessarily say that, because I wouldn't frame it that way, right? That almost makes it sound like it just depends on which team you're on. Every case is unique. We're seeing all sorts of cases getting approved. And if you need an example, we can talk about habeas corpus, which is, everybody who are going to ICE detentions and going to check-ins now. That's what we're recommending everyone to do in case you are going to be detained. Hey, I have a habeas case. I'm ready to file. Don't detain me, right? Those cases, nobody thought was going to get approved. A lot of them are getting approved. So that was amazing, right? And we just attended a couple hearings this week. Mark and Gabby, Megan, myself, with a client, and we saw all the other cases at the same time. A lot of cases got approved. Immigration judges have to be fair. The thing is, the Department of Homeland Security, they are getting more creative in their arguments. They're pushing the boundaries. Things that was okay in the past, they're now challenging and they're not agreeing to anymore. And so now the judges have to really review that and judge accordingly. And that makes it much more difficult. We also see a lot of judges retire. We also see a lot of judges get fired and get replaced. So is the system fair? The system is definitely stacked against the individual immigrant, especially if they have a bad case. But good cases, miracles are still happening. So don't just give up hope because it's like, oh, the deck is stacked against you.
Oh, they're talking about EOIR only, not federal courts.
Obviously, yeah, I'm talking about immigration court. Yeah, I'm talking about immigration court. Yeah.
How long after the issuance of legal permanent residence can one safely travel?
Say that again?
How long after a green card is given can you safely travel?
Oh, we have clients that travel before the green card arrives. So they fly in, they give the packet to the CBP officer, they enter the U.S., USCIS is processing the green card, is being mailed to their home, they pack up, they file a re-entry permit, 3 days later, USCIS gets the re-entry permit, they get the receipt, boom, they're out. We don't recommend that, right? It's definitely safer because the card processing, a lot of times errors happen, wrong name, you have to correct it with a new I-90, it's a headache. So definitely travel once you get it, but some clients just travel without it, and then once a green card arrives, once a re-entry permit arrives, send it abroad and they come back in with it.
I don't have much evidence with my U.S. spouse. He's filing my adjustment, but should we wait?
The time before you get to the interview could be 3 to 6 to 9 months. That's a lot of time, Within 3 to 6 to 9 hours, you could probably create a lot of evidence, right? So I wouldn't wait. I would file and then gather as much evidence as you can during the interim. And then when you go to the interview, you can go with like a bright smile and a big packet.
Can I travel with a green card to Somaliland, which I believe is on the 75 country banned list?
Yeah, so just like what we said earlier, if you have a green card, the ban doesn't affect you. But what would affect you is when you come back, the CBP officer will be very suspicious, right? When they have you more questions to ask. And so that's what you need to prepare for.
How long do you think the pause will take?
My estimate is 3 years.
Can you ask for a translator when applying for citizenship if you've lived here for over 20 years?
Yes. So USCIS has a requirement. You are able to take the tests and interview in your own native tongue. So that is a plus, right? You don't necessarily have to. I've been a translator for a lot of these clients in the past. And if you also have dementia and you have a waiver, then you don't even have to take the test, right? And so, yes, if you fulfill the guidelines, the requirements, it's all on USCIS website. It's very, very clear. You don't have to take a test in English.
Do you work in Georgia?
I work in California.
What's an estimate on a per case you do by your office?
That depends. Sorry, right? And the best way to, the good thing about our website is a lot of our pricing is available, right? So you can check out PERM, EB2, EB3. You can check out a lot of things. At least I think it's on there. The reason why it depends is because, how many perms is that company sponsoring, right? Are we just doing one, right? Most of the time we do like 5 or 10 per company, right? So package deal, how many H-1Bs are we doing as well as the perm? Is the perm complicated, right? And so prices are all over the place. It's like, potentially a 2-3 year long process. How expensive it's going to be in the future. There's a lot of estimates. So the fairest thing is to do a consultation. Once we know the exact situation, we give you a fair quote, right? The consultation is $250. It is not a sales pitch. We want to walk you through everything, teach you everything, and then be able to give you a fair quote.
Is it recommended to do an advanced parole in 2026?
Yes. We haven't seen any major pushbacks on that. Having it is so much better than not having it. If you don't have it and something happens to you, it's actually a big nightmare, which is something, we're constantly working on right now.
My dad's I-130 was processed today. Do you suggest we continue with the case?
Yes.
On the 75 country list?
Absolutely. Because you keep on going through that pipeline, and then you go all the way to the end, even if they, 'cause 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 even if they, like our client from Nigeria, even if it's, you're ineligible because of the proclamation, well, everything else gets still approved. If it gets lifted tomorrow, well, then he's next in line to be able to get the visa and to come to the country, right? So definitely still work through that process.
Is it a good time to file N-400?
Absolutely.
Is it a good time to do a wager for renewing your green card?
Yes, absolutely.
Are you a pro bono lawyer?
Not yet. We just established our American Immigration Lab, nonprofit, and we are going to run a lot of nonprofit clinics in this year. Maybe we'll start with 2 or 3, so stay tuned. We'll definitely announce it. If you're here, you'll probably see us from our normal channel. We created a new channel called Making Immigration Better. That is part of our nonprofit initiative. We're going to try to do a lot of education stuff on there. And then when we do nonprofit events, we will be doing a lot of pro bono cases on the spot as well. So that's a big push that we're trying to do. So definitely stay tuned. And more importantly, if you know any nonprofits who cannot, help, but they want to, let us know, right? We want to partner with other nonprofits, right? Or churches or any organizations to have a, setting and then bring the people, and then we go and we just help as many people as we can. So all of that is in the works, and we're really excited about it. Thank you for asking. Something that's dear to my heart.
Okay, we'll answer a few more questions and then get back to talking about this travel ban and this ineligibility. Do you think it's risky to be unemployed with a green card?
I think it's risky to be unemployed with a green card? It is not risky in the sense of, the IRS is not going to come after you, ICE is not going to come after you, etc. It is risky in the sense of when you apply for citizenship, when you need to make an argument where US is your home and you haven't been working, and let's say you left the country for a long time, then you don't have what's needed to overcome those hurdles, right? So if you're not working, presumably you're not filing taxes. And when the citizenship interview, they really look at those two things. And that's part of good moral character, whether you work or not, right? The American definition of whether you are a moral person is whether you are economically beneficial to the economy. That's crazy, but that's what's happening since last year. So that's the risk that you're taking.
Would I be eligible for the CCA of 2001 if my I-45 was filed when I was 17 and turned 18 when it was approved?
I don't know. Yeah, I have to research that.
If I said CSPA instead of CCA?
Oh, CSPA? Okay. What about okay.
Would I be eligible for CSPA of 2001? Maybe born in 2001. 485 was filed when I was 17. I turned 18 when it was approved. Okay.
Definitely do a consultation. The fact pattern doesn't quite make sense to me. Yeah, whether it's CSPA or not. Yeah.
You said you think the ban will be lifted in 3 years?
That's my personal opinion. So, not the firm's opinion, but based on how slow the government moves. Because look, the proclamation, right? And I guess we're going back to the news now. This pause on the 75 countries, right? There's 195 countries to 202 countries in the world, 75 countries, some of the poorer ones, but including some adversaries, right? They are reviewing the public charge rule. The public charge rule is something that the Trump administration during his first term wanted to heavily go after, but he failed at. And there was a lot of lawsuits, it got stuck. But it is his fundamental belief, as well as many people that's in his political base, that shares this belief that there are a lot of people who come into the country who take benefits. And this rhetoric of immigrants taking benefits and taxpayers are footing the bill, that is a narrative that they've been talking about. And we're not even talking about just immigrants, right? We're talking about racial tensions as well. The same group of people, a lot of them say other U.S. citizens, other racial minorities are benefit takers, and why is one group of people paying for all of it, right? So this narrative goes on, but it's easy to scapegoat the immigrants. First administration tried to crack down on public charge, meaning they're trying to deny a lot of people their visas and their green cards and their immigrant benefits and not let them in the country if they are quote unquote too poor. That is a very important message as well as objective and goal and mission that they have ever since the first administration and even before that. Now, fast forward to today. Last year they announced a new public charge policy that hasn't been, to the best of my knowledge, implemented at the USCIS level, but they can implement it at the consulate level. And this is the very first step of it. And if you've done any sort of projects, you're not going to stop the first step until the whole thing is done. So first 75 countries, will there be another proclamation that expands it to something else, right? To other countries, or more severe, maybe they will block non-immigrant visas as well, which they sort of did last year already, right? If you potentially might not leave the US on your non-immigrant visa, please pay a bond, $15,000. Well, that is a pretty much, death nail to most people in the world. $15,000 is their entire annual salary, right? So just to get a tourist visa to come visit grandma, right? Like it's pretty intense. So that is why I predict this is the first step. And there's so many things that's in the pipeline of what they're doing, and everything is just going to compound on each other and it's going to get messy. So I don't anticipate this being lifted anytime soon. Because to be lifted, it means, oh, I already solved the problem. I figured it out. I don't see anything is going to be figured out in the short term.
Okay, so we will answer a few more questions, then talk a little bit more about the news. My boyfriend came here illegally. We want to get married. Is it possible for him to get a green card?
Yes. So stay tuned to the success story where we're talking about somebody entering as a tourist and then adjusting status. Obviously, for my case, it was extraordinary ability family. They got the EB-1A approved. The whole family came in. Then they filed for adjustment. But at the interviews, he was called to 2 interviews, 2.5. So with an RFE. So it was quite complicated. And this is getting much more complicated. So I'm going to talk a little bit about that during the success story segment.
Is it critical to file joint assets as a married couple? You have an I-130 pending.
No, you could file separately.
Can I travel domestically with 3 citations, no seatbelt, didn't pay bus fare, and 2 tinted windows? I'm nervous.
What's your status? Right. If you're a U.S. citizen, no worries. If you're a lawful permanent resident, if those 3 amounts to a good moral character problem, anybody who detains you, gives you to ICE, potentially you get an NTA. Probably not, right? Traffic violations, citations are not an issue. If you are a visa holder and they see just mere arrests, what happened last year, right? A lot of international students who are on F1 visas, suddenly their visa they get a text message. It looks like scam that says, oh, your visa's been terminated, right? It just 100%, 150% looks like a scam, but it was real. ICE and the Department of State sent it all out. As long as you have an arrest, doesn't matter what it is, boom. And there was a whole bunch of lawsuits, right? So that happened in January last year. So if you're a visa holder, it could trigger something potentially. If you're not a visa holder and you're here unlawfully, well, yeah, that might be a problem.
I sent documents requesting an adjustment of status. I haven't received anything yet. Is that an issue?
No. Yeah, USCIS is just extremely slow.
Stuck on interview scheduled, but it's been after 60 days since my interview. CSPA case. Thoughts?
Nope, it's fine. Yep, we see a lot of CSPA cases that were filed. It takes a long time. I think maybe even 6 months or more.
They hold my removal of conditions after it was approved for more evidence. It's been 48 months and it's about to be expired.
It's probably an 829 case, or I guess a complicated 751 case. It sounds like it's a long time. You might want to look into a mandamus lawsuit if you have a good case. If not, get a 551 stamp.
Can I work while my renewal DACA is in process? No. And will that affect my process of getting LPR?
You need a work permit to work. Yeah, USCIS changed the policies on automatic renewals. So check that out. It's complicated. They change the rules like every 2 years, and more than that, twice a year the past few years. So this administration, as of just like a few weeks ago, changed it again. So there's no automatic extensions, especially the 540 days. Yeah. So if you don't have a valid work permit, chances are you cannot work. However, depending on how you're going to apply it for adjustment of status, maybe it's okay.
What do you think about Texas and DACA?
I think it is so messy that it is just going to get dragged out longer and longer. And I don't think, some people say it's going to be a situation where DACA holders will have different rights in different states. I don't think that's going to happen because immigration law is already overly complicated. That will create such a crazy precedent. So I don't think it'll happen.
Can you petition if you were born in the U.S. but never lived there?
Can you petition in the U.S.? Meaning maybe can you petition somebody else because maybe you were born here, you are a U.S. citizen, you left the country and you want to petition somebody else? And the answer is no. The consulates will be very strict on trying to see, well, how long did you live in the U.S.? Give us all your tax returns, right? So we routinely do this at our office in Taipei and in Shanghai. A lot of U.S. citizens left the country for decades, and then they fall in love, or they got divorced, they got married again, now they're petitioning somebody else. But they already left the U.S. for a long time, right? So now you pull their records from their 20s, right? So proving that they've been here, all the tax returns, all the social security documents. So if you've never lived here, you can't petition people.
Is a Chinese marriage green card interview takes years to schedule? Is that normal?
You mean at the consulate? Yeah, if it's I-130 NVC, the consulate, the whole process could take like maybe a year and a half. But if you're just talking about the consulate scheduling the interview, that should just be like a few months.
Oh, so this Chinese marriage green card interview, it's taking years to schedule inside the U.S.
Yeah, that's not normal, right? Like last year we had a whole bunch of these because it was within 3 to 6 months, all interviewed and approved. So if it's taking years to schedule an interview, something's wrong.
So after this marriage green card interview, she printed both our IDs and joint bank account info after the interview. Is that a good sign, bad sign?
I'm assuming the situation is you went to the interview, now everything is waiting, you don't know what's going to happen, and then now she is collecting all this evidence, and you see her collecting all this evidence. What does that mean? If you're optimistic, she is a very diligent individual. She wants to prepare her case well. If you're pessimistic, she might want to divorce you and file 751 on her own. You know her better.
What about if it's the officer who printed out this info?
Okay, sorry. I just caused some tension in your relationship there. Well, no, that's just the officer's job. I mean, typically when we go to the interviews, we have the clients bring everything, so you just give it to the officer so they don't have it. But if you didn't do that, they want to print it, they only would like it.
Okay, so on this CSPA case, here are some more details. Okay, in 2010, I was 17. My I-140 was submitted and then approved when I was 18. In 2011, category IR7. Should I file for N400 based on that info? And am I eligible for CCA or CSPA?
Wow, that's like an immigration bar question. So your CSPA and N600 is completely two different ways to get benefits, right? So let's bifurcate that. CSPA will not apply to your N600, and N600 won't apply to your CSPA. CSPA is trying to get you your green card. And then once you have the green card, several years, then you get this N600. The N600 rule, my memory of it is you have to be under 16 or under 18, depending on your sibling, and your parents have to become a citizen, and then you could apply. Gabby at our firm does most of the N600. So if you double check the requirements, you meet it, and you want to do a consultation, book with Gabby. She's part of the Spanish team.
N400, not N600.
Oh, okay. Well, that changes everything. Okay. Okay, well.
So yeah, 1745 was submitted, approved when they were 18. Am I eligible for CSPA? Should I file?
Well, if the 45 got approved, you already have the green card. And if you have the green card and you have the green card for over 5 years, you can apply for the 400. So unless there's other facts, right? But the one thing I would recommend is that the CSPA memo has been essentially erased. So it goes back to the old CSPA law, which is the adjudicating time of the I-130 can be deducted from your age. Sounds like you might be able to qualify, right? Especially your 17, 18 age. So check it out. I think you have a chance.
Terrence from a banned 75 country traveled to the U.S. with a pre-banned 551 stamp on their passport.
Yes, because even if they got an immigrant visa without the 551 stamp, without a green card, before the ban, you can still fly to the U.S. and activate it, right? So the ban is to stop new visas being issued. So if you had a 551 stamp that proves that you are a green card holder, you can come in.
I'm from Pakistan, part of the 75 country ban, or FODS, and I'm visiting the U.S. on B1, B2 in March, 6 years after my last visit. Well, I need to present some additional documentation at the port of entry.
Run me through that again.
Yeah.
It's really important.
Visiting U.S. on B1, B2.
Okay.
It's been 6 years since I visited last.
Okay.
Will I need to present some additional documentation at the port of entry?
Okay, yes. So everybody, return flights, hotels, event schedule, short duration, right? So if you're here to see your family, 1 week, 2 weeks, return flight, hotels, activities, things booked, conversations about your visit, your family members, their names, their phone numbers, all these things you should have, and they're ready to be able to answer. What do you do for a living? Don't say you don't work, right? I mean, that's just a lot of times officers are, well, okay, if you're not working back home, you're definitely coming here to work. But that's one of the things that they care most about. So prepare those things well and explain. There is a high chance the officer might only give you 2 weeks, 3 weeks, 4 weeks for your entry. That's still better than just directly canceling your visa and making you turn back, right? So there's also a chance the officer still might give you 6 months, right? So check your I-94. And what the officer says is different than what's on your I-94 record when you check in. So whatever happens, hopefully you enter successfully. Go online, check your I-94, and see exactly how much time you're able to stay in the U.S. because that online notice is what controls, not what the officer says.
Okay, so I want to talk about the success story today. Okay, describe a bit what it's like.
So the main story the main success story that we want to talk about today is an adjustment of status after coming to the country as a B1, B2 tourist visa. The client in this situation was an EB1A client, and their entire family got the essential visa approved, but they didn't want to go to the consulate to do it. They were, visiting the US. It was a nice vacation. The priority date became current. They were rejoicing, so they wanted to file a adjustment of status in the US. B1, B2 enter, adjust status. This happened in 2022. And I remember when the client walked in and we're talking about it, and I was like, okay, this other office sent you over to do it. Okay. So I'm assuming there's a CSPA problem, right? You want to freeze your child's age. Like, no. I'm assuming, an agent did your EB1A and you don't have any of the EB1A documents and it was all lost. No, they actually have all of it. I'm like, okay. Then I'm assuming you have other inadmissibilities. That's why you don't want to be at the consulate, right? All these common things from their home country. No. I'm like, why are you here? And they're like, oh, because we came in as a tourist and now we want to do adjustment of status. I'm like, that's it? That's why you're coming to us? You don't need to come to us for that. Are you sure you want to do this? They're like, yeah. I'm like, all right, well, okay. And then so Andy's team took over and we processed it. Prior to last year, entering as a tourist and then filing adjustment of status has never been difficult. You want to check your boxes, you want to do it right, but you're just saying, I was a tourist, I have valid I-94, and then after the 90 days, I changed my mind and I want to file for adjustment of status and I qualify and here's everything. And almost all the cases we file get approved, right? So it was not a hard case in 2022. However, after we filed it, one interview. The first interview, we told them, just go by yourself. It's not a big deal. We coached them on what to say. We coached them on how to prepare for the EB1A because that's part of the adjudication process now. They talk about where they're living in the US. They practice their English. We went through all the swearing in process, the whole family. Coached them. They went, okay, no problem. They came out. It was great. They were very thankful. Things were fine. Then got a request for evidence for all these other things that they wanted to see. All right, well, then we prepare it. We send it in. They don't have to go to the interview, but we explain it. And then just a few weeks ago, they got called to another interview. And now they're like, oh my gosh, in 2025, we saw all of this, right? They came in 2022, right? Now it's 2026 for the second interview, for their adjustment of status, for their EB-1A that was approved, that was the priority date became current, and they filed the adjustment of status, and they've been just living off of their work permit and their travel permit as a whole family. They already went to one interview. They had a request for evidence. They had another request for evidence earlier on. And now it's a second interview. I told them, you probably should get an attorney to go with you. So we arranged an attorney. We prepared everything again. Just like the first time. They went, it was done, and now the whole family got the green card. This entire process and what happened at the interviews, that's what I want to share with people. Now, USCIS officers don't really like to do interviews. They want to approve cases fast. They have a strict time limit. They have to adjudicate so many things within each case already. They have to check your 45. They have to check your prior DS-160s with the consulate. They have to check your eligibility on how you got it, the I-140 or the I-130. You know, everything just takes 10 minutes, 30 minutes. And during the interview, they only have a short amount of time. So your goal is to convince them as much as possible within the least amount of words that you qualify. And in this day and age, the one additional thing that they're extremely concerned about is that why are you doing this change of status? And you came in as a tourist. What was your return ticket? What was your home life like beforehand, before you came to the U.S., right? Like if this was supposed to be vacation, well, where were you going to return to? Your lease agreement, your work agreements, all of it. You can't just leave. I mean, who goes to another country and just stays there for 4 years, right? I mean, most normal people don't. So in your case, if you did that, well, please explain. So there was a lot of this type of prep for this B1, B2 change to adjustment of status. And that's with everything being approved. And we're seeing this more and more now, especially because the consequence of this is if the 45 gets denied, then they get a notice of intent to appear to court, and maybe they have to withdraw the case or they have to leave the country and then go through the entire green card process again overseas, which could take another year. So there's all of this calculation that people are concerned about now. In the past, it was a no-brainer. 99% of people would fly to the country and do adjustment of status. USCIS officers know that that was common. Maybe they turned a blind eye. Maybe they didn't. Maybe it was just not important. It was not a high priority. But now it is a high priority to the point where they are doing the thing that they least prefer. USCIS officers that I know hate rescheduling interviews. They are, I don't know if they're docked for it, but they're definitely wasting a lot of time and effort. They don't even like giving requests for evidence because in the past, they used to get a point for everything activity they did. They do one interview, they do another interview, they get 2 points. They give you an RFE, they get a point. Every action that they do, it counts to their productivity. Now, productivity is tracked by only approval or denial. So if they had to do 5 extra things before they get to an approval or denial, well, the government workers, they don't want to do extra work. And in this case, because it was a B1, B2 tourist visa entry with adjustment status, it made a simple situation extra complicated. And at the end of it, the client said, that's why in 2022, we hired you guys. We wanted this kind of assurance for like the past 4 years. They definitely got their money's worth. Very happy for them. I was incredulous as to why they needed an attorney's help at that point in time. But I think that's why they're EB-1A people. They have the foresight to see it's going to get complicated. So they'd rather have somebody shielding them this entire time. So I'm glad the case is done. I'm happy for them. And I hope this news is able to help anybody who is planning on doing a B1, B2 to adjust. It's still doable. Just definitely want to double or triple down on the preparation. And that's it for the success story. If you have any questions, feel free to check us out on our website, book a consultation, check out our other videos. I hope these success stories are helpful for you guys to see exactly what's happening on the ground every day. Please let us know how we can help. Okay? Take care. Bye-bye.